Hi, I'm Jane Reardon at the Illinois Supreme Court Commission on Professionalism. Welcome to Reimagining Law. In this video series, we're exploring how legal professionals are changing up the delivery of legal services to better meet today's consumers. I'm joined today by two thought leaders in this space. Mary Ann Mason, a retired justice of the Illinois Court and the co-chair of the Chicago Bar Association, Chicago Bar Foundation Task Force on the Sustainable Practice of Law and Innovation, and Zack DeMeola, Director of Legal Education and the Legal Profession at the Institute for the Advancement of the American Legal System in Denver. Thank you both for joining me.
Wow, Jane, that was a mouthful. Excellent. Yes. For having me.
I had to practice that. Thank you very much for both of you having such long organizational names.
Great.
Thank you, Jane. Thank you for getting it right. And for short, we will call our organization IAALS.
Thanks.
Okay, so we tried to come up with an acronym for our task force, and it comes out to SPOLI. So we've decided not to market ourselves that way.
Probably a good move, Justice. All right, so we're going to talk legal services regulation, which is handled by the state Supreme Courts. And the state Supreme Courts occasionally change up the rules of professional conduct that govern lawyers to match changing times and the changing practice of law. But we're in a moment that's different. Zack, can you explain what this more national movement around attorney regulatory reform is and why it's being considered now?
Yeah, absolutely. So the issue right now is that too many people cannot access the legal system to protect their rights and to resolve their disputes. That's a problem. In our democracy, the legal system is the foundation of our rights. And if people can't actually access them, we're going to lose a lot of the public trust and confidence at a time when already the public has problems with with the way the government, I think, is running many different things. So we need to fix that problem. The studies show that upwards of 76% of all cases involve litigants, people who have to go to court without lawyers. And at the same time, lawyers are having a difficulty actually reaching clients in new ways. That's a problem given the advances in technology. Lawyers are behind many other industries. So at IAALS, we've created the Unlocking Legal Regulation Project, which is about rethinking the way that we frame the delivery of legal services so that we can increase access both for people in need, but also for lawyers who are looking for sustainable practice.
Thank you. Justice Mason, the Chicago Bar Association and Bar Foundation created a task force on the sustainable practice of law and innovation. What were the concerns that underlie that creation of the task force?
Those concerns, Jane, really go hand in hand with what Zack just articulated. On a parallel track, you have lawyers today who, particularly in solo and small firm settings, are not able to practice law at the top of their license. Studies show that on average, a lawyer spends about 2 hours a day actually practicing law. The rest of the day is spent running the business of owning a law firm, business development, preparing, sending, collecting bills, actually running the office. And law school doesn't teach you to do any of those things. So lawyers are struggling to run a business that they're not trained to run. And over time, adjusted for inflation, their profit has steadily declined. On a parallel track, as Zack mentioned, we have more and more people showing up to court unrepresented by lawyers. And these are typically in high volume courtrooms, which, while they may not be high value cases in terms of lots of damages or the prospect of a big recovery, they have profound impacts on individuals' lives. Landlord-tenant disputes, mortgage foreclosure, consumer debt, domestic relations. And if the majority of people in what is designed to be deliberately an adversarial system, meaning both sides are represented, if one side shows up without a lawyer and the other side has a lawyer, it really, as Zack pointed out, undermines confidence in the entire system. So that's what the task force set out to address, these two parallel concerns.
So this idea of regulatory reform seems arcane to some. And as you point out, lawyers are struggling just to make a living. Why should they care about this issue, and how do you get them to care? Zack?
Yeah, so these two issues, the access to legal services for people in need and the issue of lawyers struggling to sustain their practices, I actually think these are two sides of the same coin. If you can allow lawyers to be more innovative, to be more efficient, to even work with others who have specialty that would help lawyers to run the business side of things, you would allow lawyers to connect to people in need in a much more effective way and impactful way than they do now. So I see this issue as being fundamental to the practice of law, not only in the service aspect of it, connecting to people, but also just in sustaining the practice for lawyers. So whenever we talk about access to justice, we're also talking about a more efficient practice, a more efficient system overall.
Yeah, I agree with Zack's observations. We as a profession have been practicing law the same way for over 100 years. And that is a lawyer without solicitation connects with a client somehow in a one-on-one relationship. The lawyer handles the client's legal matter and charges an hourly fee for that service. That model just isn't working and isn't in sync with the way every other aspect of our society does business today. Dentists, doctors, accountants, all of whom have confidential relationships with their clients, are able to advertise. They are able to use technology to connect with clients. And under today's regulations, lawyers can't. And we're just not keeping pace with how the people we serve need to be able to find us.
Justice Mason. Oh, go ahead, Zack. What were you going to add?
Jane, I was just going to add a point to that. And that's why, I mean, this is really why we do need to reimagine the way we regulate legal services. I mean, we're in an age of unprecedented disruption technologically, but we're not helping our lawyers to keep up with the times. Everything Justice Mason said, I think, is right on point with that. The framework is going to have to change to allow lawyers to practice and serve the needs not only of the people, but of the times.
So the CBA CBF Task Force Report is very lengthy, and it took on some very specific regulations to tackle this, or recommendations rather, to tackle this issue. Justice Mason, can you tell us what the key recommendations are in the task force report and what are next steps?
The task force report, all 112 pages of it with lots of attachments, makes 11 recommendations. The thing I love about the product that resulted from the task force is that the recommendations run the gamut from high tech to low tech. There's no one answer to the market failure we find ourselves in. And so one of the recommendations is that lawyers, like other professions, be able to use an intermediary technology provider to connect with clients. And this is a matching service. The lawyer would pay for that service just as you pay an IT person to set up your website. if the matching service connects the lawyer with the client, an attorney-client relationship ensues, and the lawyer is not affected at all by the fact that the lawyer has paid a fee to the matching service. They handle the case as they would otherwise. That's one of the key recommendations. The other, as I mentioned, are relooking and revising the rules on advertising and connecting with clients. The overall goal is to avoid false, misleading, coercive, or harassing connections with clients. That should be the goal. And so we've recommended changes in that regard. On the low-tech end, we've recommended that a community justice navigator position be recognized. It's very important in underserved communities to have a physical presence in the community, a trusted person, a librarian, someone connected with a not-for-profit or a religious organization who community members can go to for accurate and reliable information. We believe that having these people in the community and giving them the resources to dispense reliable information about legal problems to community residents will go a long way toward restoring trust in our justice system.
Yeah, what I like
but I could go on forever. There are lots of other recommendations.
There really are a lot of recommendations, and I think this report and recommendation reflects the complexity of the problem and today's society, and that one-size-fits-all solutions are not going to work. And today's consumers should be empowered to choose the types of services on the types of terms they want. What are the next steps?
I'm sorry, you asked me about next steps, and I wanted to make sure I mentioned that. The report has been released publicly. It's been sent to as many email lists that the Chicago Bar Association has and disseminated widely around the state. We're in the public comment period, which runs through August 21st. People can comment in writing online at the Chicago Bar Foundation's website, chicagobarfoundation.org, and we would love to hear feedback.
That's awesome. And I assume nationally as well, like from IAALS and other
absolutely
around the country. Great.
Absolutely.
Zack, can you address, I know that Illinois is not the first state to address this issue. In fact, there's task forces that are around the country. What's going on in other states at a very high level? What are some of the key issues being studied and implemented?
Sure, yeah. So the two states that are I think furthest along are Arizona and Utah, and both of those states share a lot of common recommendations, although they both propose different models of re-regulation. And that's an important point I want to make. What we're talking about here is not deregulation, right? We're talking about reimagining the way that we regulate legal services to allow for more flexibility, more options, and a more consumer-centered, I think, system. So in any case, in Utah and in Arizona, two of the main features of the recommendations there are freeing up advertising rules for lawyers. And in those states, what they've essentially done is just gotten to the core issue. The rule now states that lawyers can essentially engage in advertising and in these intermediary services so long as they're not making false or misleading statements, right? That's basically the critical aspect of those sorts of regulations. The other thing that both states have done is they've required lawyers have to keep in mind that whatever they engage in, it cannot compromise their independent judgment. That's another important key. But what they've done is they've eliminated those restrictions that prevent lawyers from partnering with other professionals or from sharing fees with other professionals or taking outside investment. Both states have done that. And I think that's overarching. Those are the two main thrusts of what's going on. Other states are looking at those sorts of solutions too, including California. That is just, California will be forming a working group very soon to look into those specific issues.
Wow, there's a lot of change considering the legal profession generally moves at a very glacial pace, but a lot of this change has happened just in the last year or two. I think it's exciting, and I thank you both for joining me on this segment of Reimagining Law. Folks, thanks for watching. Please like and share this video and stay connected with us to be updated on future episodes. Ways to keep in contact with us are in the notes. Meanwhile, be well.